Hello, sir. Am I clearly audible and visible to you?
Hi, good evening, everyone. Am I audible to everyone?
Yes, sir, you are. Okay, so good evening, everyone. Hope you all are doing well. I, Priya, the editor of Desi Kanun, welcomes you to this session with Advocate Tarun Gaur, sir. And in this session, we'll be analyzing the recent judgment, namely Vijay Madanlal Choudhary versus Union of India. And in the said judgment, the Honorable Supreme Court had upheld various provisions of the Prevention of Money Laundering Act, which relate to powers of the Enforcement Directorate, including search and seizure, arrest, and attachment of property. So, since the judgment has been released, it has been a subject of recent, rigorous debates and controversy. So, before we proceed with the session, I'd like to take a moment to introduce Tarun sir. He's an independent legal practitioner who's based out of Delhi and a criminal law enthusiast who is the founder of the Chambers of Tarun Gaur and is also an alumnus of National Law University, Delhi. His article on Prevention of Money Laundering Act analyzing the flaws in the legislation had been published on Live Law. So, first of all, thank you, sir, for joining this session and giving us your time.
Oh, you're most welcome, Priya. Just like to a little bit correct you there. I'm not an alumnus of NATU Delhi. Actually, I was already ranked one there, but I did not take admission. I got placed before the academic session could have started, so I chose to, work where I actually wanted to work. So I'm not an actual alumnus of there.
Okay, sir, can you please work on the sound? I think the mic is a bit little faint.
Is it better now?
Yes, sir, better, better.
All right. Gee, so shall we start?
Yes, sir. So my very first question to you would obviously be what were the basic observations, significant observations that were made by the Apex Court in this judgment, and considering that there has been a lot of controversy with respect to Enforcement Directorate, and there has been arrest of certain political leaders, what significance does this particular judgment hold in the present political legal situation, and what is the significance of the judgment in the current legislation with respect to money laundering law in India?
Well, the introduction that you have given actually, I don't know from where to begin because this not just this judgment, but the entire law on money laundering that we have as of now in India, the Prevention of Money Laundering Act, has always been a bone of contention. And in fact, it's a flawed legislation. And I'm not saying this right now, but I've been saying this ever since. In fact, I wrote a paper on it as well. If anyone, any of your viewers interested in it, it was published in Live Law. They can go and check it out. But this major judgment, see, when I wrote that paper, till that time there was a lot of confusion which was going on with respect to the current statute, that is the act. This time when this situation actually went to Supreme Court, so there were a plenty of petitions which went to Supreme Court. However, this judgment, there is no discussion of any sort of facts, and even we should go there because the facts, the factual matters of all the matter, all the petitions, is still sub judice. And the only things which were raised in Supreme Court were only conceptual, and perhaps that's the only thing. I can say this very blatantly. Conceptually, this entire law is very flawed, and with that in mind, see, after reading the entire judgment, I still somewhere still disagree with the judgment that the Supreme Court has given, and I'll give my reasons for it. But in order to understand what exactly is the current statute that we have in India, plus the importance of this judgment and what exactly has happened, I would like to give one background as to what exactly money laundering is. In order to understand what is money laundering, how to control it, how to deal with it, let's understand what money laundering is. Now, money laundering basically is when you even let's start with a very basic example in a very layman's term. So laundering is something when you wash something or when you clean something. When we apply that definition to money or the amount that we get, it's like laundering of money. Now that obviously literally doesn't mean that you wash your pile of cash. That's not it. But it's all about to have some amount of cash with you, which you obviously cannot use in the real world because of its source, and now you want to launder it. That means you want to make sure that it looks clean, so that when you go out and you use it, nobody will question you, and nobody can say as to where exactly have you gotten this money. Now, money laundering is not basically laundering of money. It has to be something like you have some pile of cash. And I'm telling you, I'm saying this not some property or anything. I'm saying let's take a very basic example. Let's take it cash. You have a pile of cash lying with you, or anyone have that. Now he can only use that cash if he has shown that to the tax authorities with respect to in India. So long as it's the money that he has already shown to the tax authority, definitely use that money, and you have not reported it to the concerned authorities, you cannot use it because they will definitely come to your house and they'll impose penalty on you. So, in order to make sure that you don't have to pay tax on it, and you somehow, even if you want to pay the tax, then you have to pay very less in it and go forward with using the money. So, this money laundering actually happens in three phases. One is the placement of the money, second is layering, third is integration. So, placement is when you have that pile of cash, like I just said earlier, the pile of cash you have with you try to put that into the system, the financial system of our country. That's called placement. And now, when you try to place that money, that pile of cash in the economy, you make sure that you have layered the transactions from which you have gathered that amount in such a manner that nobody can go to the source of it. Because the whole process is about concealing the process. Because if the process is not concealed, then everyone will know as to from where you've gotten the money, and then obviously there is no point of you using it. And third point is concealing the source so well that when you want to use that money, that means now you have integrated that money so well into the system that nobody can question and nobody can say as to from where that money has come, and now you're free to use that amount. So basically, in these three ways, in three steps, money laundering happens. That you have some money, you first place it in the system, then you layer it, and then you integrate it so that now you can get yourself back the money and use it. And why I've given this basic background, I'll come to it later because this background is actually very much important to understand the law that we have in country as of today and this judgment which has been recently passed. So according to this judgment, the basic definition, what we know is there has to be some ill-gotten money with you, some ill-gotten property with you, which in order for you to use it in the real world, you have got to layer the origin. That's it. However, when we look at the statute that we have, that is the Prevention of Money Laundering Act, does it even say the exact same thing? It doesn't. The definition, the very definition given in the section 3 of the act says that money laundering is basically happens, and verbatim, I'm not repeating the section verbatim, I'm trying to explain your audience in a very normal way. This act says money laundering happens when you try to place it, layer it, and integrate in the system. Only those property or those proceeds which you have gathered by virtue of commission of a crime. That crime is given under schedule of the act. So basically, what the law says, there is a schedule to the act. There are number of offences listed in it, and it says if let's say you commit any of the one, two, three offences which are given in the schedule, by virtue of doing that, you accumulate some wealth, that is some money or so, some property, some ill-gotten money that you have. Only if you try to launder it, that means if you try to place it, layer it, and integrate it into the system, that it will be termed as an offense. That's it. This is the first thing that the Act says, that it has to relate back to the offense which has been mentioned in the schedule. So let's say if something is not mentioned in the schedule, some act, and because of that act you get some wealth which people might say it's an ill-gotten wealth, and you try to use it, launder it. Will that be covered in that? It won't be covered in that, and I'll come to that later only. So as far as the act is concerned, this is the main offense the act believes about. Commission of is basically laundering of amount. That is the proceeds of crime. Proceeds of crime is the amount of the property that you receive by indulging in an offense. The offense is given in the schedule. This act had a lot of flaws in it, and to this day still has. When the matter actually reached Supreme Court, there were a lot of conceptual issues which people wanted to be clarified because day in and day out, people are facing the wrath of the system, of especially the enforcement directorate, the authority given to the act, because they have been given some power without any federal check over it. This is my interpretation, but I'm telling you, it's not something the court has said. But according to me, I feel they have given unfettered power, and people are suffering the wrath of the department. So when they reached Supreme Court, the very first part, which was the very first thing, which was actually asked from the Supreme Court was, as to what exactly is an offense. The one that I've just explained, which is already very clear even from the basic reading of the statute, yet it was the very first foundation question from the court. Because if we look at the act says, okay, look, if you commit some offense given under the act, maybe it's under prevention of corruption or narcotics, whatever it is, you have committed that offense. You have actually dealt in drugs, maybe you have accumulated some money out of it. Now you have, if you try to launder it, that is an offense. Very bare reading says कि भैया, if there is a commission of predicate offense and you gain something out of it and you try to launder it, that's when the offense is committed. So the obvious interpretation of the inference that comes out of it, कि money laundering as is defined can never happen if the predicate offense has not happened. Makes sense? Because if the predicate offense is not there, how can you say that someone is having a pile of cash and that is tainted money? We cannot say that. That gives us that the offense is actually one which is dependent on commission of some other offense. This was at least to this day, even this is my interpretation. Now I'm actually emphasizing on that because this court has taken a different view. When this question was actually being answered, this was answered by various high courts in a different form. Some high court said that this offense is actually not standalone. It depends on the commission of offense. However, some high court said that the offense of money laundering is a standalone offense. That means they said that even if there is no commission of predicate offense, yet offense of money laundering can be there. Now that doesn't make any sense to me, and to this day it doesn't make any sense to me. However, when the matter is Supreme Court, the first question when the Supreme Court answered in that judgment, Supreme Court actually said that the offense of money laundering is a standalone offense and it is not dependent upon the commission of predicate offense. However, at the same breath, the court also said that it is one offense which is predicated on upon the commission of scheduled offense. Now, I'm actually confused as to what exactly the court wanted to say because in one breath, court has said both the things. Now, as far as this contention, this Supreme Court's verdict is concerned, that it is a standalone offense, I strongly, with all due respect to the Supreme Court, obviously, and to the judges, in my opinion, I disagree with that. And now you must remember that the first background that I gave in the beginning. That's why I gave the beginning. We, to this day, the kind of picture that we have, we cannot say it's a standalone offense because it's a very simple reason. Look, I'll give that example once again. If let's say I'm I'm a dealer or I'm a trader, right? I trade in maybe clothes. I trade in some other goods, and I run my business from maybe Chavdi or maybe Sandarada. I don't know. Now I sell my products and I sell them at bulk. When I sell them, I sometimes receive some money in cash. Now what is it? Does and now this because this money that I have just gotten, somebody can say it's an ill-gotten money, somebody can say it's a tainted money. In a way, you can say it both. But and in order for me to use that pile of cash, obviously I'll have to do something about it. I cannot just use it directly because I cannot show the sale of my goods in paper because I've taken the money in cash. Obviously, there could be plenty of reasons for which I've done this, but I've done this. But does this act fall under the category of schedule offense? No, it is not there. If it's not there in the schedule, now can my act be said as an act of money laundering? Can I be charged under the act? I cannot be charged under the act. Therefore, my point to this day, even the point of petitioners who were private parties in that judgment, their point was also that according to the act that we have, according to the procedure that we have in place, this offense can never be said to be a standalone offense. However, Supreme Court said no, it's a standalone offense. But the court has now just said it, so we cannot do much about it. But the most interesting part of this judgment, because I just want to clarify that in the beginning, and I actually scared my mind. This act has been amended several times, and lately it has been amended. It has been amended quite a lot of times by a finance bill. Now, not a lot of legislation gets amended by that. In fact, that's not the proper way of amending any legislation. But this specific act has been amended by the finance bill, and that question, whether that amendment actually acts as an amendment or it does not act as an amendment, is still pending before the Supreme Court. A seven-judges bench is still looking into the matter. The name of the matter is some Roger Matthew something. It's still pending. So the court said, whatever we are discussing in this matter, if tomorrow the seven judge bench says, look, all the amendments that have happened to this day via finance bill under the act, they are non-est, then there's no point this entire judgment will go. That is one basic thing. So whatever we are discussing, it is as of today, which is there, and until the time the documentary judgment comes. So coming back to the judgment, the first point then that we thought
Sorry to
argument.
interrupt you. A few attendees are saying that there is a voice issue. So, if possible, if you could take your AirPods off and speak like this.
Is it still some better now?
Yes, sir, much better. I think it's better now.
All right, just give me a second. And am I audible now?
Sir, I think it's the same.
It's still bad.
Yeah, people say it is same and they need a like slow explanation, like a slow pace while they're explaining.
All right, I'll keep my face down, and perhaps my AC was making some sound. I guess now situation must be a little better.
Yes, sir, sound is better.
The background disturbance also, I guess.
I think it's fine now.
You can ask your viewers if it's fine. I'll try to slow my pace.
They say there's still a problem.
I'll try it. Okay, fine. Is it a little better now?
Yes, sir. You can like move closer to the camera and then speak. So I think it will be fine.
Am I audible to everyone? Because I cannot hear anyone. Priya, am I audible?
Yes, sir.
All right. So I'll just, in a brief, I'll just once again, I have disconnected the. All right. So the point that I have made as of now was the major contention was, and has always been ever since this act has come into the picture, was what exactly is the offense and whether that offense is a standalone offense or is it dependent upon some other offense. The scheme of the act, the very definition under the act says that look, if you accumulate some wealth, some property, something, some cash out of doing of some offense which is given under the schedule, and then you try to launder that money, then that amounts to the offense under the act, that is the Money Laundering Act, and that is an offense of money laundering. So that, in a very clear way, tells us that the offense as is given under the act, is there still some problem?
No, sir. No problem on my end. It's fine now.
So the point is, if there's a commission of offense and you have accumulated something, then that is an offense of money laundering. The people were worried because the different high courts in the country took different views. Few of them said that the offense as is given under the act is not a standalone offense, but is dependent on the commission of a scheduled offense, as is very clear from the act itself. However, certain high courts took a contrary view and they said, no, the offense of money laundering is not it's not dependent on the commission of predicate offense. However, it's a standalone offense. That means that even if there is no commission of scheduled offense, yet somebody can be charged with the offense of money laundering. Now the point is, and the example that I gave, was it clear for everyone, or should I give that example again? If anyone can reply to that.
Sir, I think you can repeat very briefly.
All right. So I gave an example as to why the money laundering offense as of today is not a standalone offense. Is, let's say I am indulging in some activity which is not a scheduled offense. For example, let's say I run a business. I run a business at a wholesale level. Many a times, either situation demands or some my own reasons, what I do is I
give my goods or products, I sell it to my vendors, and I collect payment in cash, which helps me as well, and somewhere helps my vendors as well. Now, obviously, this is money which I have not shown to the authorities, like tax authorities or maybe GST authorities, to which I'm liable to show, but I have not shown them. Because of that, this money can be said to be an ill-gotten money. But the point is, can I use it? I cannot use it because I have not actually shown it to the authorities where I was actually mandated to disclose it. Because of my non-disclosure, now I am prohibited from using it unless I do something about this money. That means I've got to do something to make sure that the money gets integrated into the system in a way in which I can use it and nobody can question me on that. Now, will that amount to money laundering? Very candidly, yes, that will amount to money laundering. But will that be an offense under the Act as the law that we have today? No. And why is it's not there? Because the Act says the only time money laundering will be considered as an offense is, let's say, when you obtain some money or some property, that is your proceeds of crime, which is defined under the Act. That proceeds of crime came from the commission of the offense, which is listed under the schedule of the Act. However, what I did in that example, that was not part of the scheduled offense. So in that case, even if I have committed money laundering, will I be punished for that? I will not be punished for that because that is not covered under the Act. Therefore, I've been saying this from time and again that this is not a standalone offense. It is predicated upon the commission of a scheduled offense, and that's how it makes sense as well, because you have made the Act in such a way. Perhaps if the schedule would have been absent from the Act, then the situation would have been different. We could have said, okay, fine, it's a standalone offense. However, as of today, we cannot do that. But the Supreme Court said, no, this offense is a standalone offense. But at the same time, Supreme Court also said that the authorities, that is the ED, which is there under the Act, cannot act unless there is commission of a predicate offense. Now, once again, I fail to understand as to what exactly the Supreme Court wanted to say. Now, this is with all due respect to Supreme Court and the judges who gave the judgment. I'm not in contempt of anyone. I'm just trying to give my point further, and that is, when you say, okay, look, there should be commission of an offense, that is a scheduled offense, only then the authorities should act. Then how can you say that it is a standalone offense? At least to me, we cannot say that. But as of now, the Supreme Court has sealed the deal by saying it's a standalone offense. So as of now, the problem is, even if there is no commission of scheduled offense, the authorities, like enforcement director, can still investigate you or any person for that matter if they have any kind of information or any kind of maybe whatever it is they have against you. That was the first part. Second part was as to what exactly is the meaning of the offense, as in when does this money laundering start? Because according to the Act that we have, the law says, okay, look, you have committed an offense, scheduled offense. You have obtained some money out of it or some property out of it. For the ease of access, for the ease of understanding, I'm using the term money, cash, and by over and over again, the Act says about the property. So let's say there is commission of an offense, there is accumulation of money, cash, by virtue of that offense. Now, when will the offense of money laundering start? Because the Act says it is only when you attempt or you actually carry out the laundering of money, the offense is committed. That makes sense. However, Supreme Court said that no, giving this interpretation to this section will actually narrow down the scope. We have to make sure that we give as much space for the definition to breathe. So the Supreme Court, what they said, that everything connected with the money that you have obtained from the commission of offense is actually money laundering. So in simple terms, what Supreme Court said, okay, look, you have committed an offense. By virtue of that offense, you have accumulated some money. The moment you accumulate that money, you have committed money laundering. Now, this again does not make any sense to me. And not just this, that I have accumulated the money, so I have committed the offense of money laundering. No, they have also further gone on to say, okay, look, let's say if I have accumulated some money out of that, let's say I was involved in drug selling, drug peddling. I've sold some amount of drugs to someone. I've gotten some money in cash. I've kept that bag of cash, let's say, to my friend's house or my sister's house or somewhere to my somewhere where I can take this. If the authorities catch that person, they are going to charge that person as well with the offense of money laundering, despite the fact that the process of laundering of money has not even begun as of yet. But the court said, no, you both will be liable for money laundering. It doesn't make sense to me, because so long as it's like saying, okay, look, you went outside to buy some clothes for yourself, and the moment you bought those clothes, you have actually washed them, you have laundered them. That doesn't make sense to me at all. If I, let's say, have some money because of commission of this offense, not necessarily raise the presumption that I'm going to launder it or I've already laundered it. That's my point of view about it. Priya, at this time, is there any question regarding this? Because now I'm going to move on to another part then.
No, sir, I think the case analysis was clear. You can proceed.
Then, after this, that they actually laid the foundation, what exactly the offense is, when can somebody be charged with it. Then comes the another important aspect of the act, that is the initiation of investigation, or let's say initiation of any kind of proceedings. Because lately what we have been seeing is, or I guess everyone must have seen, every second day or maybe every day there is some news over there which says, ED has raided this place, ED has raided that place, they've arrested this person, or maybe they have summoned this person, that person, and it keeps on going. The major point is, PMLA being a penal legislation, something has to be there to move the machinery into the motion. Like if the ED officers are sitting there, they cannot by themselves think, okay, look, we're going to raid that person, we're going to raid this person. There has to be something. Now, what is that thing? When we deal with other crimes, we understand that CRPC is there. There has to be one FIR for the police officials to move and to do something about it. In a way, in a simpler term, you can say there has to be a complaint for the machinery to move. In case of Prevention of Money Laundering Act, there is actually no need of any such thing. And that's the biggest flaw in the act. The act says, like I've repeated so many times, okay, look, scheduled offense has been committed. Ill-gotten money is there. That means they have committed the offense. Now let's nab that person. Let's raid that person. What in practice happens is, the enforcement director, the authorities, they register one report which they say ECIR. Now, ECIR in practice, you can say, I'm not saying it is, because now the Supreme Court has closed all the doors. But it actually does the purpose of an FIR. However, Supreme Court has said it is not equivalent to FIR. I'll come to it. So the ED officers, what they have to do is, they have to have some information regarding commission of a scheduled offense, and only when that happens, that they start their investigation regarding whether there is some ill-gotten money, and if there is some, whether the process of laundering has started or not. And because in order to move that, in order to do anything, there was some requirement, or earlier there was requirement, they have to write the reasons down as to why they are arresting someone, why they are attaching some properties of someone's or anything. Now it's like the ECR that they actually write, or I don't know even if they write or not, because the Supreme Court clearly said, no, you don't even have to write that. So now the situation is like, the court said you don't even need an ECIR. If you get the information, you just go ahead, you raid whomever you want, you attach whatever you want, you arrest whomever you want, and we'll take care of rest. That's what, again, no disrespect to anyone, just my analysis on this thing. This is what the Supreme Court said, because when the commission of scheduled offense has to be there for the offense to be there, how exactly do we say that some offense has been committed? When the FIR gets registered? No. Because when the FIR gets registered, we can only say, okay, fine, somebody saw something happening or someone is a victim of something. That means he's claiming that he has been victim of something. He went to police station, he got a complaint registered. That's it. Then the police investigates. During investigation, police has all the powers, whatever power they have, they use it, they do their work. They submit the report in the court. When they submit the report in the court then went on to see what exactly they have collected. They go on to frame charge if there is some material on record prima facie to say, something has been, some offense has happened. Else, the court will discharge the accused. So till the time judicial application of mind has happened, you cannot specifically say, at least even prima facie, you cannot say, okay, look, this person has committed this offense. Because what the police has investigated, what they had, what the report, yani ki challan, the charge sheet, whatever they filed, it's all about their opinion about the investigation, the material they have collected. Judicial mind is not there. And I have always made a point in courts as well and in my paper as well, that the only way when the authorities under the act should actually start to move or to act is when there is some sort of charges framed against the person for the commission of scheduled offense. Because that's when you can actually say, okay, look, the court has applied its mind. That means the judicial mind has been applied to the predicate offense. Court has found that yes, prima facie there is something that we can say, okay, the scheduled offense has been committed. Now ED should proceed further. Okay, look, maybe there must be, if in case he has committed some offense and before he done away with the property that he has accumulated by the commission of the offense, perhaps we should start doing our investigation. But what they do is they don't wait for anything else. The moment they get to know that some FIR has been registered or so much so a complaint has been given by any person to any authorities which is commission of scheduled offense, they directly come raiding at your houses, at your office places, and whatever they can lay their hand on, they're going to attach it. This is the sad reality of today. And the Supreme Court, this judgment actually.
I'd like to ask. So you said that in case they find out that an offense has been committed, they conduct raids. So do they not make any difference between minor offenses or like some offense that would qualify as a grave offense? Or if there is some demarcation of that sort, so how do they determine that?
See, that's again, it's a very good question, but the point is, or unfortunately, there is none. So even if let's say there is an allegation of some public official committing corruption of maybe 5,000 rupees maybe, and then if and the CBI registers starts investigation about it and the charges are framed. Let alone let's say charges are also not framed. It's only a complaint has been made that somebody has asked for 5,000 rupees in bribe. That's it. Correct. Now the money has not even delivered yet. The offense has not even been committed yet. Yet, let's say that public official have actually accumulated some wealth by his savings of lifetime. Maybe he's in his 40s and 45. He has had some savings of 4-5 lakh rupees. The moment ED gets reft of that somebody made a complaint that he asked for a bribe of 5,000 rupees, the ED is going to raid his premises, attach the 4-5 lakh rupees or 10 lakh rupees, whatever his saving is, in the name that look, we have information that you have committed money laundering. That's it. And they don't even give any kind of reasons for doing that. I'll come to it when I'll come to arrest and bail and all that. But the point I was trying to make is because there is no foundation as to when the authorities should move, that lack of foundation has actually given unfettered powers to the authorities to do whatever they feel like whenever they feel like. And that, in my personal opinion, is actually not how the criminal system, any sort of criminal law, is actually to be moved. After they have actually moved themselves, they start their investigation. What they have to do is, look, sometimes you either arrest some person, maybe a police officers also do that if they have some solid proof against someone, or even not solid proof, somebody is not cooperating, they go and arrest some person on whom they have suspicion yes, he might have committed an offense. In this situation, according to me, CRPC has a lot of safeguards which are also to be incorporated under the Act, but the court has specifically negated them, which the Act itself says that CRPC, the provision of CRPC should be applicable to the act wherever they are lacking. And there are plenty of situations. So that brings me to this next thing, that once they have moved themselves, they have actually started investigating. These officials, what they do is, they sends out a notice, or you can say summon, under section 50 of the act. Now that summon, or you can say notice under section 50, is so vague and so ambiguous that, let's say, Priya, if you get a notice from section 50, and let's say I'm the ED officer, right? I'm investigating something about you. Now I will not mention in that summon anything whether you are an accused that I'm investigating or you are a witness. Nothing. I'm not going to mention anything. When you receive the summon, you think that, okay, this information has been called from me and I've been called at this stage, perhaps I should go and join it. Because you, being a law-abiding citizen, you will definitely go there, join their investigation or whatever inquiry they are doing. In practice, what they do is, when you go there, when you actually go and give the statement, give the documents which have been called from you, they try to get a confession out of you. Now, see, I'm saying they try to get a confession out of you. That means even if you're guilty, you're not guilty, doesn't matter. They'll try to get what they want from you. They try their level best to make you write and also sign whatever they want you to write and sign. Based on whatever information they have about you, they want it to be correct. So they actually compel you to do that. Now, when that happens, we know in any sort of criminal jurisprudence, if you go to a police station, let's say, or some police official calls you, he takes your statement, he cannot let you sign it. He cannot make you sign it. Even if you sign it or doesn't sign it, it is not going to form part of evidence. Because everyone, since time and again, Supreme Court has dealt with so many cases and given so many guidelines out of that you cannot just compel. And we know the state of police we have in our system. What kind of torture they inflict? It's not physical torture, sometimes it's mental torture as well. So the points raised by the petitioners were, okay, look, this section 50 notice that you give to someone, you call that person to your office, he joins the investigation. When he comes there, you torture that person, not physically, maybe mentally. You take the statement, or maybe sometimes, I don't know, we see, being a criminal lawyer, being a defense lawyer, I can say this very well. I've seen plenty of agencies, they don't even take your statement, they just give you something to sign it. That's the harsh reality of it. So coming back to the point, they say, okay, look, you call somebody, whoever you called, he comes to join the investigation, you make them sign certain papers, and then you arrest them. Now, this doesn't seem fair to me at all. Neither this is in line of our criminal jurisprudence. It is not. So the point raised was, okay, look, because you are under custody, even if not custody, because as of now you're not arrested, but you are in a place where the testimony is being compelled out of you. So is that not violative of Article 20, Sub-Article 3 of Constitution? So the court said that, look, while under Section 50, and before I said what the court said, there is also a provision, which is Section 65 of the Act, 63 of the Act, which says, if you do not give correct answers to the questions being asked to you, then you will be liable to penalty and imprisonment of certain amount. That means you will be punished for that. You will be prosecuted for that. Now, my take on these two sections is completely different. I feel that these two sections have not been read properly in the court. That's what I feel. Because according to me, if you read Section 50 and you read Section 63, under Section 50, the only time one is actually obliged or maybe under an obligation to, sign whatever the ED people are saying to sign, or to give correct answers, is when somebody is referred under Section 14. Any Section 14 of the Act deals with Section 14 of the Act deals with professionals like CS, maybe banks, maybe advocates, maybe those authorities, who deal with some people in public life. So they're bound to have some records of those clients. Let's take an example of CA. Let's say the example that I gave in the very beginning. So that guy, who have got pile of cash with him because he sold something and he took the money in cash. He goes to CA. And obviously, at the end of every year, after every 3 months, you have to file the advance return, GST return, everything. So the CA is the one who is taking care of your returns. That CA will fall under Section 14. If ED authorities, let's say, Priya, in your case, ED officers issue a notice under Section 50 to your CA and ask that person to give information regarding you, the documents that you have submitted there, and the returns that he have filed, then that person is under an obligation to give all those documents and give all the correct answers that he have with respect to you. That's the only point and in only dimension in which ED officers can compel you to sign anything. That's my take on it, because as I read this section, if you remove section 50 subsection 1, the rest of the sections is deal with, you have to give the correct answer. You cannot otherwise, if you don't give the answer, you will be punished. They have nothing in there, anything that if you don't give the answer or if you don't sign it, then we're going to punish you for that. However, the way these authorities read these sections is completely different. What they try to do is they try to create a mental pressure on the person whomever they have whomever they have summoned, and what they do is, okay, look, give us the answer we want, sign this document that we want, else you will be punished under Section 63. And whatever you say today, see, if whatever you say and you sign it, it will be used against you in the court. That's what upheld by the court, because the court said, look, whatever your statement you're giving to a ED officer, you're not giving to a police officer. And I fail to understand, and this was also another point raised by the petitioner, which said, look, when I'm in the custody, maybe I'm not handcuffed, maybe I'm not officially arrested as of now, maybe there is no arrest memo of mine, yet when I'm in their environment, they are committing mental torture, maybe giving me mental trauma. Perhaps they're forcing me to sign something I've never even done that something, but they want me to take the blame for it. What should I do? Is that not is that not violation of my right? But the court said, look, the officer that have called you is not a police officer. Therefore, they can't help you. You have to do as they say. If they want a statement out of you, whatever statement you give, that will be used in the court. It will be evidence. It will be used against you. And it is not violative of your fundamental right. And you know why it is not violative of your right? Because when you were summoned, which I mentioned earlier, you don't know, Priya, when you were summoned, whether you are an accused or a witness or you are just somebody as an ancillary. They need some sort of information. That's it. You have no idea. And the moment they get what they want from you, maybe a signed confession, maybe some other thing which they actually trying to elicit out of you, what they'll do is, now they'll arrest you without even telling you the grounds of arrest, without even giving you any copy of ECIR, which they so-called say that they have an ECIR. They'll not give you a copy of that. So the court said, no, when they called you, you were not an accused. However, it is only when you were arrested that you become an accused. That goes against I guess this goes against everything I know about criminal jurisprudence. The very basic fundamental principle is that you have to inform whomever you are arresting for any ground. You have to inform that person of the ground. You have to tell them the accusation against him so that he can actually rebut it better. And by better, I'm not saying that he'll flee the system. I'm just saying he'll be better prepared. But that's not the case. And then this arrest thing, when they arrest somebody under Section 19, because the third part was, and the later part was Section 19, which was challenged. The people said, look, even if we accept everything, now that you have arrested someone, at least give that person the copy of ECIR and some reason so that he can challenge that. Now, by the ED or the officers, whomever are acting, they are executive authorities. They don't have the power to curtail somebody's freedom, because for that, courts are there to make sure whether your freedom has been taken by due process of law or not. But that will only happen when you give some reasons to someone who has been arrested. I mean, even in preventive detention legislations, supplying of reasons and a copy of record is a must when you arrest someone. I mean, preventive detention laws are the most aggressive laws that we have in our country. That gives the authorities under those legislations to arrest someone without there being any report, without there being any FIR, without there being anything, just on the basis of mere suspicion, they can arrest anyone. but they cannot keep that person arrested, because the moment they arrest that person, they've got to provide them with reasons, so that when you approach the court, you have something to show for, look, I have been detained illegally, and the court can also see that. And trust me, preemptive legislations are those which deal with a very high threshold, something where our national security is at threat. But in money laundering, I feel it's not at par, and it's even worse that you do not even get the reason as to why you have been arrested. Now, after you have been arrested, what this section says is the authority will have to give the reasons, whatever they have noted down for them making the arrest, to the adjudicating authority. Now, the very first obligation is to give it to adjudicating authority, not even to a court as of now, but to adjudicating authority. That means executive have to give the reasons to executive and to their boss only. Now, what are the chances that the boss is going to, disagree with their junior or whatever it is? Because obviously, because with their permission only, these people, they started investigation. With their permission only, they arrested this person. Why will he overrule his own judgment? He will not overrule. And after giving those reasons to the adjudicating authority, then the third obligation comes on them to give those reasons to the magistrate, produce the person who has been arrested before a magistrate, and then authorize his detention. Now, when somebody gets arrested in any penal jurisdiction, obviously he has to be produced before a magistrate, because of the same reason that the judicial mind has to be applied to make sure that if somebody is being deprived of their liberty, then it should be by the judicial mind, because judicial mind is more trained to understand as to whether that is even required or not required. Now, when the person who was arrested gets brought before the magistrate, at that point, that person has a very basic right to object to his detention, to object to his custody, and to ask for bail from the court. But in this situation, again, this is not possible. Because once you are arrested, you can take it from me 100%, the court is not going to listen to you at all. They are going to authorize your detention. They're going to send you either in prison or in the custody of authorities. That's what, because it's not that the courts are such, it's that the courts have been forced to do that. Because the moment you arrest someone, even if you don't arrest someone, section 45 of PMLA is something, I'll come to it later, which gets triggered. And that makes it impossible. Section 45 read with section 24 of the Act makes it impossible for any court to grant bail to anyone who has been arrested by the authorities under the Money Laundering Act. This entire section was actually challenged before the court, but the court said, look, whatever you are saying, you are just simply, raising your apprehensions that maybe ED will abuse this power, maybe ED will not abuse this power. So maybe because the power to arrest has been bestowed at such a higher official, he'll only arrest people who are actually required to be arrested. But I say, is that also not making an assumption? Did the court or did the Union of India also not make an assumption when they say, no, simply because we have given this power to higher ranking official, perhaps he will not abuse it? Whereas in this country, at least in my experience, I have seen the higher the position, the more the abuse of process is. But that's my apprehension. So as of now, if you are arrested, you can take it guaranteed, you will be behind the bars and there will be no saving, at least even if you are innocent. After that came because a lot of things were discussed in the judgment, but I'm not going to get into every concept which was discussed in the Act. I'm only trying to give or explain those concepts which are actually applicable in the practical world and what is happening around us, so that everyone can relate as to how things happen and what is happening. So therefore, I'm just skipping all those. I'm not getting into the history of the Money Laundering Act as to why it got to be implemented, why the amendments are going. I'm not getting into that. So after this thing that somebody has been arrested now, either sent in the custody of the authorities or sent behind bars. Now what will happen? Because CRPC says you cannot keep anyone behind the bars for long, and time and again you've got to get authorization from the court for the detention. Same thing is applicable under this Act as well. That obviously, if you are putting somebody behind the bars, then obviously you need some kind of judicial permission for it. You cannot keep somebody behind bars forever. Now the point is, who will give that permission? The moment you arrested someone, you brought that person within 24 hours before a magistrate. Maybe area magistrate, maybe duty magistrate, it can be anyone. But what after that? Who will authorize the detention after that? Will it be special court, which is which is actually made under section 44 of the Act? Is it going to be local magistrate in whose area jurisdiction the person has been arrested? There is no clarity. There's total ambiguity in that. In practice, what happens is the special court, which has been made under this act, they usually take up these matters and then they try to, they authorize the detention. But there is nothing there. The act is silent about it, and this ambiguity is very, very important to be noted, because that I'll come to later when we come to bail. Now, these special courts under section 44, usually whenever any special court is created under any special statute, what happens is those courts, they have been bestowed with the power to deal with the offences or try the offences given under that act only, because obviously to deal with those offences only, you have created a special court. Otherwise, the normal courts were there to deal with anything else. For the first time, I've seen this. The legislature has given these special courts not just the power to try the offense given under section 3 of the act or under the Money Laundering Act. They have also given these courts the power to try and adjudicate upon the scheduled offense. Now, this is the most, I would rather say, disturbing part for me, at least. I mean, let's take an example. If somebody is accused of committing the offense of corruption under the Prevention of Corruption Act, we know under Prevention of Corruption Act, there are special courts already in picture, already in existence, to deal with these offences, to try them, and they are specialized courts for that. Now, by virtue of this legislation, because somebody is charged with Prevention of Corruption Act, the ED people will come into the picture. They'll start their own investigation. They'll arrest the person. They'll start their own proceedings before the court. Now, when they start their proceedings before the special court under PMLA, now this court have been given the power to adjudicate on the corruption issue as well. And that's baffling for me. Because what exactly are they trying to do? Does that mean that all the courts, which were special courts made under PC Act, they are non-functional anymore? Are the special courts made under NDPS Act, are they non-functional now? No. Either you make them non-functional or you make them functional and you don't give this power to this court. Now they have said that if the court feels, if the AD authorities make a representation before the court, okay, look, we want both the trials to be conducted together, then if the court agrees, then the court will try both of us together. Now tell me one thing: if I'm the judge and I'm dealing with the offense of money laundering, and now I get an application from the ED authorities, and they say, okay, look, we want the offense of corruption to be in your court only because you have the power to try both. I actually agree with that. I get those files in my court. I start hearing both the matters. Now, what is the possibility that I will give an acquittal? Chances are very high, and I'll stretch out my neck and say it's 95% that you can then forget about your acquittal. Even if you are an innocent, you can forget about acquittal. You can take it, you will be convicted, and nobody can do anything about it. Because it is very simple. If the court, let's say if I acquit somebody in the Prevention of Corruption matter, then obviously I'll have to acquit him under another Money Laundering Act as well. However, if I'm dealing with both the offences, there'll be a lot of pressure over me. And the pressure is very obvious. It will be on me, and I will not acquit them. However, if the situation would have been different, the PC Act trial would be conducting in a separate court, which was designed to deal with it, and the money laundering one was in my court. Perhaps then I would have waited for that court to deal with it, and the court which is specialized to deal in those matters. Then, if that court returns a finding of acquittal, then also it will be very easy for me to acquit that person, because then nothing is left behind. But this section was when challenged in the court simply said, once again, the private parties are actually raising some assumptions. It's their apprehensions that their trial will be prejudiced, their rights will be prejudiced. It will be on a case-to-case basis. The judge will decide. That means the judge who's presiding over the special PMLA court will decide. By saying that, the court left it that it is constitutional, it is reasonable. For me, according to my interpretation, it is not. After this comes the point of bail. Now, if anyone is interested in the practice of money laundering, I would rather say that they must pay attention to this thing, because it's a little complicated, but I'll try to simplify it. And it is something which is actually very debated and needs to be understood from every angle in order to make sure something gets out of it. Because no matter how good you are in studies, how good you are in practice, you cannot make out anything out of it. Even we cannot make out anything out of it. But it is very important to understand as to what it is that we are trying to understand it is. So when we come to bail, the provision of bail is given under section 45 of the Act. That section simply says, look, all the offences under the Act, that is the offence of money laundering, because that's the only offence under the Act. First of all, it will be cognizable, it will be non-bailable, and if you are accused of an offence under the Act, then and you apply for bail, the court will not give you bail unless and until an opportunity is given to public prosecutor. Fair enough, it should be given. And number two,